Discrimination in reverse. For years, supporters of civil rights programs claimed to want elimination of racial consciousness so that Negroes would be treated as individuals without regard to race. They now admit that they want racial discrimination in favor of Negroes. Among the Negro leaders who make such open admission is Adam Clayton Powell, the man who boasts that he told the President of the United States what to put in the civil rights message, which became the Civil Rights Act of 1964. This law would guarantee no civil rights for anyone. It would rather enforce the demands of racial agitators that the American constitutional system be set aside for the purpose of giving preferential treatment to Negroes. The federal government orders government contractors to hire Negroes in all types of jobs regardless of need or personal merit, and in violation of anti-discrimination laws. That is a summary of my report on discrimination in reverse. The full report after a message from my sponsor. For years, supporters of civil rights programs claimed they wanted to eliminate racial consciousness in the United States so that members of minority groups, especially Negroes, would be treated as individuals without regard to race. But they falsified their objective. They do not want to eliminate racial prejudice, they want to create it. They do not want Negroes to be ignored as Negroes and treated like other human beings. They want Negroes to be given preferential treatment because they are Negroes. Martin Luther King openly admits that he wants discrimination in reverse. He wants preferential treatment of Negroes in the form of financial aid from the federal government to provide Negroes special advantages in employment, education, housing, and so on. Lincoln Lynch of the Congress of Racial Equality demands not only that government give Negroes preferential treatment, but that it force private individuals and organizations to discriminate in favor of Negroes. Adam Clayton Powell goes even further. He says, quote, "In the school systems north and south, there should be immediate busing in and busing out of the black neighborhoods. In employment, I want upgrading and retraining for Negroes and legislation for the school dropouts, those Negro youngsters who don't qualify for graduation. And there should be preferential hiring. I say, hire the black man. Preferential hiring is just. The black man has come to the conclusion that the white man has given all he's going to give, and that what the Negro must now do is fight for what he wants. I think there should be one place set aside in Harlem where white people wait on Negroes." End quote. United States Representative Adam Clayton Powell has been associated with many Communist Front organizations. He has been criminally indicted for income tax frauds. His tours of foreign nightclubs with his secretaries at taxpayers' expense have scandalized the nation. His hatred of the white man has been openly expressed and broadcast to the nation. This is the man who boasts that he told President Kennedy what to put in the civil rights message of June 19, 1963, the message recommending legislation which became the Civil Rights Act of 1964. The Civil Rights Act is the most dangerous piece of legislation considered by Congress since the Reconstruction era. It violates numerous provisions of the Constitution. It discards ancient fundamental principles of American jurisprudence. It neither provides nor guarantees civil rights for anyone. It would rather enact into law the demands of racial agitators that the whole system of American constitutional government be set aside for the purpose of giving preferential treatment to Negroes. The principle of trial by jury, first enunciated in the Magna Carta, signed by King John of England at Runnymede, June 15, 1215, quote, "No freeman shall be arrested and imprisoned, or dispossessed or outlawed or otherwise molested, unless by the lawful judgment of his peers and by the law of the land." End quote. King John's Great Charter was the foundation stone of Anglo-Saxon common law, which became the common law of the United States. Our founding fathers, recognizing the ancient principle that all persons accused of crime have a right to be tried by a jury of their equals, asserted the principle in the Constitution, reasserted it in the Bill of Rights. Article 3 of the Constitution says the trial of all crimes, except in cases of impeachment, shall be by jury. The Sixth Amendment says, in all criminal prosecutions the accused shall enjoy the right to speedy and public trial by an impartial jury. The Seventh Amendment says, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Under the Civil Rights Act of 1964, the Attorney General can obtain federal court orders against any individual or group of individuals, including state and local officials, whom the Attorney General accuses of violating any provision of the law. No matter what the court orders, the accused must obey or be charged with criminal contempt. If the accused tries to resist or contest the court orders, the court can find him guilty of criminal contempt, levy heavy fines upon him, and send him to prison without a jury trial, even without a public hearing if the court please. By close vote on May 6, 1964, the Senate rejected efforts to amend the Civil Rights Act to require jury trials in criminal contempt proceedings arising under the bill. Several jury trial amendments are still pending. All of them, however, place limitations upon an American's constitutional right to trial by jury. The Mansfield-Dirksen proposal, for example, would guarantee trial by jury in criminal contempt proceedings under the Civil Rights Act only in cases involving fines of more than $300 and jail sentences of more than 30 days. This Mansfield-Dirksen proposal, though it would render the Civil Rights Act a shade less vicious, is nonetheless an affront to constitutional principles. The Constitution guarantees trial by jury for persons accused of crime, and Congress has no authority whatsoever to change any provision of the Constitution. Let's review a few things that have already happened under the guise of civil rights. In March 1964, the Illinois Fair Employment Practice Commission completed investigation of a complaint by a Negro that he was denied a job with Motorola Incorporated because of his race. Motorola said the Negro had failed to pass the company's standard ability test. The Illinois FEPC ruled that Motorola must abandon ability tests for job applicants because ability tests are unfair to Negroes and others who cannot pass them. The FEPC said that employers in Illinois must adjust their hiring practices to reflect general economic convictions of economic need among minority groups, and must move positively to achieve a proper balance of minority groups in their workforce. Thus, the Illinois FEPC, created in response to demands by racial agitators that all racial discrimination be eliminated in employment practices, assumes authority to control personnel policies of private employers in order to force them to discriminate racially. In every state where agitators demanded and got fair employment laws to outlaw race as a qualification for employment, and to force employers to hire on the basis of merit, regardless of race, the agitators then decided that Negroes were not getting enough jobs on merit, and now demand quota hiring, which means that employers must violate the fair employment laws and hire a fixed percentage of Negroes because of their race, regardless of personal merit. Quota hiring on the basis of race to favor Negroes, in open violation of anti-discrimination laws, has been practiced in New York longer than anywhere else. In fact, New York City has more laws favoring Negroes than any other place. Yet Negro dissatisfaction is greater there than anywhere else. The city has become a cauldron of racial tensions and violence. Racial segregation in the public schools of New York was outlawed years ago. Children were assigned to schools not on the basis of race, but on the basis of geography, sent to the schools nearest their homes. The result was that in predominantly Negro neighborhoods, the schools were predominantly Negro, and vice versa. Agitators did not complain that schools in Negro neighborhoods were inferior to schools in white neighborhoods. They complained that, quote, the absence of white children from Negro schools means a shortage of ambitious, education-minded models for Negro children to copy, end quote. They who had demanded the outlawing of racial considerations as a basis for assignment of children to public schools demanded that the laws be violated so that children could be assigned to schools on the basis of race. New York City adopted the costly, tension-building, socially disturbing, time-consuming practice called busing. children are not permitted to attend schools in their own neighborhood if Negro leaders allege racial unbalance. White children are hauled across the city to attend schools in Negro districts, the Negro children being hauled in another direction to attend schools in white districts. But racial agitators still are not satisfied. They now demand abolition and complete rebuilding of the New York City public school system on a design not intended to educate children, but to enforce an artificial racial mixing that may satisfy the agitators. The federal government orders business firms working on government contracts to hire Negroes in all types of jobs, regardless of merit or need. But that's not enough. In May 1964, President Johnson sent letters to companies with government contracts, virtually ordering them to lobby for the Civil Rights Act. People who understand and respect the principles of freedom had better exert some pressures in the other direction. Every United States senator should receive millions of letters demanding rejection of all civil rights legislation. I am not talking about supporting various amendments to tone the Civil Rights Bill down. The Americans who know and care, who value their liberty, of whatever race, creed, or color, should demand that the federal Congress reject all civil rights legislation. Goodbye. God bless you. For the documented text of this broadcast, send 25 cents to Dan Smoot, Dallas 14, Texas, and ask for 457, Discrimination in Reverse. 6 copies, $1.